Hello guys, welcome to another episode of this particular video. As usual, by name I am Jafet Okaka Ibosetali, and today under criminal law we are going to be looking at mens rea. Initially, we have talked about the meaning of an offense, we have talked about the classification of an offense, we have talked about actus rea, and we have looked at the principle of causation under actus rea. But for today, we are going to be looking at mens rea, and we are going to also be looking at the components that constitute mens rea, the things that if actually they exist, it will be said that there is actually mens rea. So now we will begin with mens rea. Now you know that for mens rea, also known as mental element, so mens rea is known as mental element. Also known as mental element is a common law doctrine of no liability without fault. So that was the major reason for mens rea, that there is no liability without fault. For somebody to be at fault, for somebody to be guilty, he must have that mental element. That's why it says no liability without fault. You can't be held responsible when you are not at fault. You can't be held responsible for action when the mental element was not even present. So that is it for that. Now, in the case of Fowler versus Paget, the court held that a person cannot be convicted of a crime unless it is proved that he had the guilty intent. So you see, guilty intent is a component of mens rea. When there is guilty intent, it is said that there is mens rea. So the court is trying to say that a person cannot be held liable, a person cannot be held responsible for a crime unless it is proved that he had a guilty intent. That's what the court held in this particular case. So for a person to be held liable, there must be guilty intent. There must be an intention to do it. The person might have been reckless, negligent, but there must be an intention. That's what the court held in this particular case. Now, in moving forward, you must note this, that mens rea, which is the mental element, is different from motive. The mens rea, the mental element, is different from motive. Mens rea, which is the mental element, means guilty intent, as we see in that case. But for motive means the reason why you did a particular thing, the reason why you committed an offense. Now let's look at it. It is important to state at this point that intention is not synonymous with motive. Intention and motive are not the same. The mental element, the mens rea, and motive, they are not the same. They are not synonymous. You can't use the two together. So they are not synonymous. Motive is generally immaterial. Now, you must note that word, immaterial. I never said motive is inadmissible. I said motive is immaterial. It's admissible, but it is not material. It does not hold enough weight in the scale of justice. In the scale to actually see which one there's more evidence, which party have more evidence. Motive does not hold any weight. It is immaterial. The law does not look it as something substantial. Now, for this particular purpose, let's look at section 24 of the criminal code. Section 24 of the criminal code. Now, at section 24 of the criminal code, the third paragraph of section 24 of the criminal code, you see that it is stated, unless otherwise expressly declared. That's section 24, third paragraph. Unless otherwise expressly declared, the motive by which a person is induced to do or omits to do an act or to form an intention is immaterial so far as regards criminal responsibility. That's what section 24, the third paragraph is saying. Say the motive by which a person is induced to do or omits to do a particular act is immaterial as far as regards criminal responsibility. It is immaterial. It is not that it is not admissible. It is admissible, but it is immaterial. It is not substantial. So let's move forward. Now you must let me give you a particular scenario. For example, Mr. A, Mr. A 5 years old daughter is asthmatic. Mr. A 5 years old daughter is asthmatic and had an heart attack at midnight, and her inhaler could not be found. Mr. A rushed to the nearby hospital, broke into the nearby hospital, took an inhaler and gave it to his daughter. In that particular instance, the law is still trying to tell you that motive is still immaterial. So you see it now. The reason why Mr. A broke into the pharmacy store was to save his daughter life. That was the motive. That was the reason. Your daughter is dying. It's at midnight, and your daughter is asthmatic. So your daughter needs inhaler to save her life. No, that's a very deadly situation. And Mr. A, what did he did? Mr. A ran into a pharmacy store. He broke into the pharmacy store and he took an inhaler and gave it to his daughter. Now that's a very good motive, but the law is still trying to tell you that it is immaterial. Because it is immaterial, there was a guilty intent in that particular. You definitely know that breaking into that pharmacy store is bad. So it is intention that matter. It is intention. You know that breaking into that store is bad. It was intentional. You did not mistakenly break into the store. So you see the intention. You did not mistakenly break into the store. You were fully aware of what you were going to do. But so that's the intention. But the motive now is the reason. The reason why I break into it was because I want to save my daughter. The reason why I break into this store was because I was dying of hunger. So motive is immaterial. Now there are components that have been acknowledged and which have indeed proven to be helpful in determining the existence of measuring. Now, there were components in artillery that were formulated to determine whether there is an artillery. But now there are also components that have been formulated to determine whether there is actually measuring. You have components that have been formulated. So this particular component include negligence. So when there is negligence, there is measuring. Intention. When there is intention, there is measuring. That's what the law is saying. When there is negligence, the law is saying there is measuring. When there is intention, the law is saying there is measuring. When there is recklessness, the law is also saying there is measuring. When there is knowledge, the law is also saying there is measuring. So let's first of all look at these components one by one, step by step. So the first one we are going to be looking at is intention. Intention. We are first going to be looking at intention. Now, for intention, this is the actual state of mind of the person at the point of committing the act or omission. This is the actual state of mind of the person. This is the actual state of mind. You are breaking into a store. What's your state of mind? Are you drunk at that particular moment? Are you insane at that particular moment? Are you intoxicated? Were you forced to go into the store? So that's your state of mind. But if you were not forced, if you were not drunk, if you were not insane, and you know what you are doing, and you just purposely break into that, so there is intention. So intention is the actual state of mind of a person at the point of committing the act or omission. So you now move forward. And they also say one intends the consequence or consequences foreseeable, then it is said that one possesses the requisite intention. What does that mean? This particular one, this thing means that one intends the consequence. So when the consequence of your action is foreseeable, when you know that if I pick up this gun and I pull the trigger, somebody will die. Now you are able to foresee your consequence. You are able to foresee the consequence of your action. That's what we call foreseeability. You are able to foresee the consequence of your action. So the consequence of your action, pulling the trigger, is that somebody might die. So the law is trying to say, by the time you are able to foresee that the consequence of your action, then it means that there is intention. And when there is intention, there is measure. But if you cannot foresee the consequence, then it necessarily means there is no intention. Now, let's then look at, in explaining this, let's then look at the case of Arrow versus Forkena. Arrow versus Forkena. Now, Mr. Forkena went to steal some bottles of rum from a shop, and in the process, some rum fell down. So Mr. Forkena, he went to a shop. This man went to he went to a shop. He went to a ship. Sorry, he went to a ship to steal some bottles of rum. So in the process of stealing these bottles, some bottles actually fell down, and fire broke out. So as this bottles fell down the ground, fire broke out. On a charge of setting fire to the ship, the court held that he did not possess the intention of destroying the ship. That's what the court held. The court held that he did not possess the intention. Yes, he went to go and steal. He went to go and steal some bottles of rum from the ship. His reason for going there was to steal the bottles of rum. He did not have the intention of setting fire in the ship. He had the intention of stealing. Yes, that's fine. But the intention of setting fire on the ship, he did not have intention. So the court held in this particular case, there was no intention. Now, there is a particular scenario that is present here, and the scenario is if Mr. A, now if for example Mr. A wants to shoot Mr. B, Mr. A wants to shoot Mr. B, and in the process of shooting Mr. B, Mr. A misses it, and the bullets move and hit Mr. C. Does Mr. A have an intention in that particular scenario? That's a very good question. Mr. A wants to kill Mr. B. He wants to kill him. He points a gun at Mr. B. He fires the bullet, but he misses it, and the bullet went to go and hit Mr. C. We say that Mr. A have an intention in that particular scenario. Now, in answering this question, let's then look at the case of Arrow versus Lamata. Okay, Arrow versus Latima. Sorry, Arrow versus Latima. Let's look at this particular case in answering the question of that particular scenario. Let's look at this particular case. Now, in this case, the defendant was involved in an argument with a person described as Mr. C. The defendant was involved in an argument with a person described as Mr. C. The defendant swore his bet. He removed his bet, and he swore his bet at C, intending to cause him harm. Now, he intended to cause this Mr. C harm. The defendant, he want to use this bet to hit Mr. C. He want to use it to hit Mr. C. And he intended to cause him harm. The bet bounced off C and hit another person. Now, the bet did not hit the Mr. C again. You want to hit Mr. C, but the bet bounced off and hits another person, which is described as Arrow. So the bet hits Arrow. Now let's go forward, causing him serious injury. Now, he wanted to cause this serious injury to C. Now, the serious injury had been caused to another party, which is Arrow. Now, what happened? What will the court say? Let's go forward. When charged with an offence of maliciously and unlawfully wounding Arrow, the defendant argued that he did not possess the required measure against the victim. That's what the defendant was saying. The defendant was like, I don't have the measure. I never aimed to hit Mr. Arrow. It's Mr. C I wanted to hit. It's not Mr. Arrow. It's Mr. C I wanted to hit. It's not Mr. Arrow I wanted to injure. That's what the defendant was arguing in court. He was saying, I don't have the measure. I don't have the intention. Now, what will the court say? Now, let's go forward. On appeal, it was held that where a defendant has the required measure for an offence but injured a third party, where a defendant has the required measure for an offence but injures a third party, that's another person, the law holds that the malice that the defendant holds is transferred to the inadvertent victim. That's what the law is saying. The law is trying to say that if Mr. A Mr. A has malice. He have the intention of killing Mr. B. Mr. A have the intention of killing Mr. B. Then Mr. A hold a gun, he points it at Mr. B. The bullet missed Mr. B, it hits Mr. C. What the law is trying to say that the intention, the malice that Mr. A have been transferred to Mr. C. That's what the law is saying. So the law is trying to say Mr. A will be guilty. And that's what the court held in the case of Arrow versus Latima. Said the malice that party has been transferred. The malice the defendant has been transferred to the other victim. So that is it for that. Now, let's move forward. Since we are still under intentional. So since we cannot certainly discover the intention of a man, it can be drawn from circumstantial inferences. So since we cannot discover, since in the words of Brown CJ, where he said that even the devil cannot discover the intention of a man. So since we cannot discover that intention of a man, the way to do it, we can do it through through the reasonability test. We can do it through circumstantial inferences, and we can do that through the foreseeability test, where you're able to foresee the consequence of your results. With a reasonable man in your condition do this particular thing, then you also use circumstantial inferences. Circumstantial. The court will look at the circumstances of the case to actually see whether there was misery. To actually see whether there was misery. So now let's look at a particular case to explain this particular thing. Let's look at a case to explain this particular thing. Now that's bring us to the case of Ngun versus Aru. In the case of Ngun versus Aru, to explain the way intention can actually be cut from Ngun versus Aru. So in the case of Ngun versus Aru, the accused person aimed a blow at his brother. The accused person aimed a blow at his brother with a heavy axe. He aimed a blow at his brother with a heavy axe, but he turned away the sharp edge. So in an axe, there's a sharp side of the axe. He aimed it at his brother, but he removed the sharp side. He did not use the sharp side to hit his brother. So you see the scenario, you see the circumstances. So he used the sharp side. He did not use the sharp side to hit his brother. He turned away the cutting edge of the blade and struck him only with the wounded scruff. Only with the wounded scruff. The wounded place he used to hit him. The brother died. The court accepted that the accused may not have intended to kill. However, it still amounts to the offense of murder if the accused intended to cause some grievous harm. So you see this particular scenario, the court is trying to say, yes, although the accused may not have intended to kill him. Now, how did the court know that the accused may not have intended to kill his brother? How did the court know the intention of the accused when the devil cannot even know the intention of a man? How did the court know it? It was based on the circumstances. From circumstantial inferences, you could see that the act of the brother, he removed the sharp side. He did not use the sharp side. He just used the wounded place of the axe to hit his brother, and the brother fell down and died. So based on the circumstances, though you cannot know the intention, but based on the circumstances, based on the circumstances, you can be able to deduce whether there was actually an intention. So another test is the reasonability test. Also comes into play. That is what an ordinary man would, in all circumstances, be able to foresee the natural and probable consequence. What a reasonable man, what an ordinary man would be in that particular circumstance, will he be able to foresee the end consequence? Will a reasonable man in the accused's shoes, will a reasonable man in the defendant's shoe, will a reasonable man in his shoe be able to foresee the consequence, will be able to foresee the probable results, be able to foresee the end result of his acts? That is a particular question the court will ask. So this is it for intention. Intention is different from motive. intention can be quoted for circumstantial inferences from the circumstances, as seen in the case of Ingun versus Aro. And you can also see that. In Aro versus Fakuma, if where a particular result is caused and the defendant did not intend to cause that particular result, then he is said to have not possessed misery, as seen in the case of Aro versus Fakuma. So that is it for intention. Then we also discuss transfer of malice, where we use the case of Aro versus Latima. So that is it for intention. So we are done with intention. So intention is one of the components. If intention is present, then the court will say there is misery. If intention is present, the court will say there is misery. So now that is it for intention. Let's then look at another component. Just the way the court will say there is misery intention, there's still another component that the court will say there is misery, and that is negligence. Let's then look at negligence. Now, let's look at negligence. Now, for negligence is a situation. Negligence is a situation where a person might not have foreseen the consequence, but ought to have taken care to prevent the occurrence of the acts or omission. Where a person may not have foreseen the consequence, but ought to have taken care to prevent the occurrence or omission. This is where a reasonable man's standard takes in. The question can be, what is expected of a reasonable man in the accused standing? So this, like I've stated, negligence is a situation whereby a person may not have foreseen the consequences. Now, let me give you a particular scenario. Mr. A was employed by Mr. B to clear his farm. Mr. A was employed by Mr. B to clear his farm. Mr. A told Mr. B, "I have come, clear my farm." So Mr. B was clearing the farm. Then subsequently he started smoking cigarettes. Then from there, Mr. B slept off, and some part of the cigarette that had fire or lightning, then made the bush or the forest to start burning. Then made the farm to start burning. In that particular scenario, you will see that there was no intention. The Mr. B was not able to foresee. He was not able to foresee the end results. He was not able to foresee that I'm smoking and this thing there's fire on it. And if I fall asleep and drop this thing on this ground, this forest can catch fire. Let me off it very well. He was not able to foresee the circumstances that will happen if he behaves a particular way. So in that particular scenario, you can say that Mr. B was negligence, and the law will say there is misery for being negligence. That's what the law will say. Why? Because he did not take extra care. Yes, he was not able to foresee the results. Yet he was not able to foresee the end consequence. But the law will say that you ought to have taken reasonable care. That's what the law will say. And the law will ask the court is going to ask a question. Will a reasonable man in the accused standing, you are in the bush, you are with cigarettes. Yes, you cannot foresee, but a reasonable man will say, this thing is burning, I need to dispose it very well. We are in dry season, this bush might catch fire. That's what a reasonable man might have said. But the accused feeling so flamboyant, not even caring, not even giving due attention to it, just drop it down. Then the bush started catching fire. So the court will say you did not take reasonable care. You have misery. That's what the court will say. So in explaining this, let's then look at the case of Edu versus COP. Let's look at the case of Edu versus COP in explaining this particular scenario. So a post office clerk gave his keys to the gates containing parcels. A post office clerk gave the keys of a gate containing parcels to his assistant. So he gave it to his assistant, contrary to the departmental instruction. The departmental instruction is that don't give this key to your assistant. Hold it to protect the parcels that are in the cage. So hold it. It was contrary to the departmental rules. But no, he went ahead and gave it to his assistants. Now let's go forward. And a parcel was lost. After giving the key to his assistants, a parcel was lost. A parcel got missing. The mere fact that the accused was not aware of his duty to take care and was imprudent was enough to uphold his conviction. This was negligence. The accused was not he was not able to foresee the consequence. He was not able to foresee the end result. So that in that particular instance, you can say this accused, in the case of Edo versus COP, was negligence. He did not take reasonable care. He was just negligent. He gave the key to his assistant, which was contrary to the departmental dues. So the court will say you are negligent. And for that reason, despite the fact you could not foresee your end result, but because of the fact that you do not take reasonable care, you are negligent. That's what the court will say. So that is it for negligence. So by the time there is intention, there is misery. By the time there is negligence, there is misery. Then let's now look at the third one. And that third one is recklessness. Let's now look at recklessness. What's the difference between recklessness and negligence? What's the difference between recklessness and negligence? Now, let's look at recklessness. It is a situation where a person foresees the consequence but does not desire it to happen. It is a situation where a person foresees the consequence but does not desire it to happen. How does that? You can foresee you can foresee the consequence, but you don't desire it to happen. In negligence, you cannot foresee the consequence, so you definitely not desire it to happen. So in negligence, you cannot foresee the end result. You cannot foresee the consequence. But for recklessness, you can foresee the consequence, but you don't desire it to happen. At the same time, you can foresee the consequence, but you don't want it to happen. Now, let me give you a particular scenario. A particular scenario will be the case. A particular scenario will be a situation. A particular scenario will be a situation whereby you are riding at the top speed. You are on top of a bike. You know, there are scenarios in which a person will be riding a bike, they might stand on top of the bike and be speeding or be celebrating something. So he's on top of the bike. He's speeding, or you are riding a car, you are speeding, you are running at his top speed. In that particular instance, something must have told you that the way you are driving like this, you can have an accident too. You can have an accident. You must have been able to foresee it that if I continue driving like this, I might have an accident. But what do? You say, don't worry, I trust my skill. I don't want it to happen, but I trust my skill. The skill I have will make it not to happen. If I continue driving like this, I know I might get an accident, but the skill I have, don't worry, it's not going to happen. Despite the fact you can foresee the end results. So subsequently, you have an accident. Then you are saying there is no misery. There is misery. There is misery. You were able to foresee the end result. That's what the court is going to say. Now, in explaining this, let's look at the case of Metropolitan Police Commissioner versus Caldwell. Let's look at this particular case of Metropolitan Police Commissioner versus Caldwell. Now, in this particular case, it was held that a defendant would be reckless if they foresaw a risk. If they foresaw a risk and went on to take it, they foresaw the risk. If I speed with this motor, accident might happen. No, don't worry, I will take it. I will do it. Or where a risk existed and the defendant gave no thought of the risk existing. There is a risk going on. You can see people, you can see small children playing football close to the road, and the road is slippery. You can see the risk. Road just fell. The road is slippery, and small children are playing, but you continue speeding. Then maybe for instance you somersault and hit the children. You first of all foresaw that risk, but you did not want it to happen. You foresaw it, but you did not want it to happen. The law is trying to say you were reckless and you will be held liable. So for now, you can also see the difference between negligence and recklessness. In negligence, you cannot foresee your consequence. But for recklessness, you can foresee it. Just that you believe in your skin and you don't intend it to happen. That is it for recklessness. Now, let's then look at the next one, which is the last, and that is knowledge. That is knowledge. Now, what is knowledge? Now, the accused must have knowledge of the existence of a particular circumstances. If the evidence in support infers that the accused had knowledge, then misery is present. Then misery is present. Let's look at the definition of knowledge by Black Law Dictionary. How the Black Law Dictionary define knowledge? Let's look at the definition. Black Law Dictionary define knowledge as an act, as an awareness or understanding of a fact or circumstance, a state of mind which a person has no substantial doubt about the existence of a fact. It is a state of mind in which a person has no substantial doubt about the existence of a fact. There's no doubt at all. You know what you are doing. That's why it's called knowledge. You are aware of what you are doing. You know the results. You know the end consequence. You can foresee the end consequence if you are caught. That's knowledge. That's why Black Law Dictionary says in which a person has no substantial. There's no doubt. There's no doubt. There's no doubt that if I'm caught, I may go to jail. There's no doubt about that. You are fully abreast with it. So for knowledge, an example of knowledge would be a case of 419. Yes, a case of 419 in which people are into fraud. They are into fraud. They are into internet fraud. So they are defrauding money from other people. In that particular scenario, there is knowledge. You can't say there is no knowledge. Those people that are into their business, they know what they are doing. They know what they are doing is bad. They know what they are doing is a crime. They know if they are caught, they might go to jail. There is knowledge in that particular scenario. So that is an example of knowledge. You know your consequence. You know the end result. So that is it for knowledge. So these are the components that makes up misery. So these are the things that the court will look at. The court will look at it. Is there intention? If there is intention, then the court will say there is misery. Is there negligence? If there is negligence, the court will say there is misery. Is there recklessness? If there is recklessness, the court will say there is misery. Is there knowledge? Well, this person aware of it. If there is knowledge, then the court will say there is misery. So that is it for misery. So we have earlier said that there is no liability without fault. So for somebody to be at fault, there must be liability. The person must be liable before he can be at fault. There must be an adversary and there must be a misery. But however, for every rule there is an exception. Yes, there must be an adversary. Yes, there must be a misery. But for every rule there is an exception. And one of these exceptions is the issue of strict liability. There are some cases where there are strict liability. The law does not look into your intention. The law does not care whether there is misery or not. When you commit this particular act, the law they don't want to hear of your intention whether there is misery. The law will just say you are guilty, strict liability. Now, in explaining this, let's look at section 31, subsection 3 of the Child Rights Act. Section 31, subsection 3. This is just an example. There are other instances in which the court will not even look at misery. But this is just one particular instance. And that's section 31, subsection 3 of the Child Rights Act. That is where a person commits have sexual intercourse. Where a person have sexual intercourse with a child. The law does not care whether you had intention or not. That one is strict liability. You will be convicted of that particular act. So first of all, let's look at section 277 of the Child Rights Act. And section 277 defines a child as a person who has not attained the age of 18. That's what this section says. Section 277. A child is a person who has not attained the age of 18. Section 277. Now let's then go back to section 31, subsection 3. Section street liability, where misery is not even necessary at all. Now let's look at section 31 subsection 1. It says that no person shall have sexual intercourse with a child. That's section 31 subsection 1. Now look at subsection 2. A person who contravenes the provision of subsection 1 of this section commits an offence of rape and is liable on conviction to imprisonment for life. That's what subsection 2 is saying. That's what section 31 subsection 2 of the Child Right Act is saying. Say when you have a sexual intercourse with a child, and it was defined in section 277 as a person who have not attained the age of 18. Subsection 2 is saying when you have sexual intercourse with a child, it's going to be regarded as rape, and that person is liable upon conviction to imprisonment for life. Now let's look at where street liability comes into play. Let's look at subsection 3, paragraph A to B. Subsection 3 of section 31, paragraph A to B. Let's look at it. It says that where a person is charged with an offense under this section, it is immaterial. See what this section is saying. Section 31, subsection 3 of the Child Right Act. Say when a person is charged with an offense under this section, it is immaterial that, now look at paragraph A, the offender believes the person to be or above the age of 18. It is immaterial. It is immaterial that Mr. A did not know that Mr. B have not reached 18 years. It is immaterial. Your misery is not even needed. That is what this section is saying. Now, let's also look at paragraph B. Paragraph B says the sexual intercourse was with the consent of the child. You can't also say the child gave me consent to have sexual intercourse with her. The court does not care. The court does not care that you did not have the intention, that you thought that the child was above 18 years. The court does not look at that at all. It is street liability. So these are the exceptions. These are some exceptions to the rule of misery. So to the rule of misery. You can also go and look at section 363 of the Criminal Code, which says that in the case of proceedings in respect of an offense under the proceedings section, it is immaterial that the offender believe the girl to be of or above the age of 16 years. It is immaterial. It is immaterial that the girl was given with her consent. So it is immaterial that you believe the girl to be above the age of 16. This is what you can see in section 363 of the Criminal Code. So these are some instances in which the court, they don't want to look at the misery. It's a street liability. So this is it for misery. And we have looked at the components that constitute misery. And we have also looked at the exception, that there are instances whereby the court does not look at whether there is misery or not. So by name, I am Japhet Okaka Tali. Thank you so much for watching. Thank you.